Yeah. Sorry, to move forward, we need to use this one and backward this. For next page, this one, and for back, this one. So this one for back and this one. Okay. And mouse is not working? Okay. Mouse working, but easy. Okay, let me check this. Sure. Keep silent. Please be seated. Shall we start? Okay. Please sit and maintain silence, please. So, good afternoon to all. So, yesterday we were discussing about international trade law, and here we discussed that what is the sources and all, and we were dealing with e-commerce. Okay. And what was e-commerce? Electronic mode of transaction. If we are trading something through an electronic media, it is known as what? E-commerce. Okay. And this e-commerce has its origin, if we can say, it is after globalization. There had a serious tremendous increase in trading and all. So, in order to facilitate trading in a very smoother way, we had something known as what? International trade law. And while doing the trade, we follow the paper-based traditional method, which is called contract. So for trading and all, we need some kind of agreement, right? So that agreement was what? International commercial contract. Okay. So gradually, when the states are developing, there was a need to do the trade in a very fast mode. Okay, so for that purpose, it being introduced a special process called what? E-commerce or electronic transaction. One of the benefit of this transaction or the benefit of this area was that it will make the entire process very smoother and also in a very fast manner. Okay, so we can see that certain provisions of this e-commerce have been taken from modern non-economic commerce and also from the UN Central. And UN Central was what? It was a convention which has been made which sets out certain rules and regulations so that the same provisions can be used for or that can be applied in the case when we are doing international trade and all. Okay. So this UN Central and this model law on electronic commerce sought to provide a set of internationally acceptable rules with an aim to remove legal obstacles and increase legal predictability for e-commerce. So you know that every country or every nation has their own domestic laws. And if we follow the same, it will create some kind of contradiction between the nations because every country is following their own domestic laws with regard to contract and all. It is very difficult for other countries to follow a particular kind of contract if they follow that particular law. So there must be a kind of general rule through which this trade can be done. Okay, so this UN Central and this MNET, that is the modern non-economic commerce, provides certain kinds of provisions through which we can do the e-commerce and all. Okay, so the model is not that much comprehensive in the sense that it doesn't contain all the elements which are needed for e-commerce, but still it frames some of the principles. What are the principles? Principle of non-discrimination, principle of technological neutrality, and functional equivalence principle. So with regard to this, if we discuss about non-discrimination, so we all have studied in our constitution and all that is what is discrimination, what is non-discrimination. Okay. So what is non-discrimination in the area of international trade or with special effect is e-commerce? So what happens is that we are traditionally following the paper-based method of contract, that we are signing it, then we are recording, then we are doing all those things. It is a traditional method. But this electronic commerce, which came into existence, it does not create any kind of disparity. So that this electronic commerce cannot be accepted as a valid document or a valid process. Because it has the same validity like the traditional method of contract, but the approach is little bit different, but still it will make the same thing. If we are doing a contract through a traditional paper-based method, and we are doing a contract through what? Electronic mode, it will create the same effect. So, if we are doing a contract through this electronic media, it doesn't make any kind of disparity, that it is something which is different from the normal contract. So this principle states that the contract which is normally being done, the contract which has been formed through this electronic media will have the same effect And this e-commerce or e-contract cannot be neglected or ignored for the matter that it is not the paper-based traditional method of contract. So, in that sense, no or there is disparity will not be created or any kind of discrimination is not being made with regard to contract and all. So, discrimination is not allowed. Okay. Second one is technological neutrality. This union system and this modern non-economic commerce provide some provisions so that the technology can also adopt. So no provisions are therein so that it will create anything or any damage to the technology and all. So the technological provisions are there in the UN system and the NECLO and the e-commerce can use those provisions with regard to contract and all. Then functional equivalence principle. It is the same thing which has been discussed earlier, that this traditional paper-based method of contract and this e-commerce will not be placed in a separate area, that one is in electronic mode and the other one is a traditional method. So such disparity has not been made. It should be treated as equal. So equality in the sense of commerce or contract has been given under the provision of the law or the provision which has been stated in UN Circular Modern Non-Economic Commerce. Okay. Next topic is international taxation. So you have very well know about tax law, hopefully. So what is the taxation? And what is international taxation then? So when we are bound to pay tax for certain products, or if you purchase something, we have to pay tax alone. Yeah. So why the same term has been used in international scenario? Because we are dealing with the chapter which is what, or we are dealing with a subject which leads to international trade. Okay. So trade is what? We are exporting something, we are importing something. So obviously tax will be there. So something what happens is that if a person is living in a country and he is operating some business on some other country, but at the same time he has to pay the tax for that country and as a resident of a particular nation. So something happens that double taxation will be there. Okay. So tax is what we pay for the product and something known as double taxation which has been paid by a person who is doing business in some other country while he is a resident of some other country, but he has to pay the tax twice for the same product. Okay. So here the taxation is something, it is a study or determination of law on a personal business subject to the tax laws of different countries or the international aspect of an individual country's tax law as the case may be. So it is something, international taxation is something which is related to the study of tax which has been given by a person as a citizen of that particular state and also it is doing some business on another state, then still he has to pay something called tax. Okay. Taxation is definitely the study of tax. But coming to the double taxation agreement, it is something the same thing like we call it as DTAA, that is double taxation avoidance agreement. So this agreement has been formed with the main object behind it was that if a person do a business from a country and he is living in another country, then he has to pay what? Double tax. So in order to avoid such kind of imbalances, what has made this treaty has been made, this agreement has been made. So whoever, which countries are the party to this particular agreement, they are bound to follow the provisions and the statute also law that they can't impose double taxation. They can't impose taxation for the product twice. So it is applicable to those countries who are the party to that particular agreement. So it provides the benefit that a person has not to pay tax twice for the same product. So that was the DTAA, that is the double taxation avoidance agreement. Sorry. So what does it say? DTAA or double taxation avoidance agreement is a tax treaty signed between, if we take an example of India or other country, if India is having an agreement with one, a contract with one another country, and if they are doing any trade and if they are purchasing anything, they have to pay what? This double tax. So in order to avoid the scenario, in order to avoid the situation, this agreement has been formed so that the person must get some right. He must not be level twice for the same thing. Okay. So the need for DTA arises out of the imbalance in tax collection on global income of individual. So if a person aims to do business in a foreign country, he or she may end up paying income taxes in both cases. That is the country where the income is earned and the country where the individual holds his or her citizenship or residence. So the same thing, if a person is a citizen of a particular state and he is doing business in some other state, still he has to pay the tax for the income he is receiving. So in order to avoid such situation and to avoid such kind of imbalances in the economy, what was introduced? This double taxation agreement was introduced. The last one is business. Here we came across with certain kinds of risk analysis. So if we are doing certain kind of trade and all, what happens is that there are many areas where risk may arise. With regard to what we can say that in the area of transportation or in the area of certain kind of credit, and in the case of the commercial area, then in political field, we may face certain kind of risk. So if we are doing trade, we must have to analyze in which area we can face risk and all. And analyzing those factors, we can do the trade in a more better way. So risk is something which causes which enter a business or which can reduce the expansion of a business. So the main thing is to find out the reason and to analyze the area where the risk is involved and to find out a solution and to eradicate it. So that is called risk analysis. We have to analyze the particular risk and we have to eradicate it, then only we can do the international trade in a better and smooth way. So what is this risk? It has been explained like, we know that the business involved in international trade have to deal not just with risk locally, but also other business development risks such as ethics, transportation, intellectual property, credit, currency, and a lot more. Because we know that we are not doing the trade within our area, that is not within the territory we are living. We are doing some transaction or some business extraterritorial, that is across the border. So if you do things like that, if we trade and if we sell something like that, we have to or we will come across a certain kind of risk. So the thing says is that in international trade, this risk analysis is one of the important factors. Because if we can't analyze any kind of risk, we can do the trade in a more better way. So it is very important in international trade law to find out what are the risks in a particular area. So analysis is one of the major things or one of the most important things in international trade law. So the assessment of risk in the national trade plays an important role in deciding the mode of payment to be used for the settlement between buyer and the seller. So if only we can analyze this, then only we can come across with the solution that if there exists any kind of dispute, then only we can find out if we have that kind of analysis, then only we can come across with such kind of disputes. What really happened? Where was the problem? Then only we can find out the risk of that particular area and we can find a solution to that particular dispute between the buyer and the seller. If we have no idea where this actual risk is there will be no solution and there will be no reason or we can't do anything if the buyer and the seller come across with any kind of problem. So it is very important to find out the main area where the risk is being emerged and to find a solution in order to provide grievance if in case there arises any dispute between the buyer and the seller. So there are many types of risks Like in commercial area, we may face risk, and in legal area, then in political, cargo, credit, foreign exchange, like that. In commercial field like that, if the what is being in like what are the main things happening trading in our national international market, and if we don't know about the trend, and if we are doing the same pattern, we are following the same pattern, what will happen is that we will come across with loss. So first we need to find out where the actual problem is. So we have this problem, or we have this risk in commercial area, and while coming across to the legal area, we know that every country has their own domestic law. So first of all, we have to find out if the law of our country is in contradiction with the country. So if there it is, then the solution will be like that. We have to form a set of law which is uniform for both the country, and we can do the trade. So legal risk is there. When coming to cargo, because it is obviously an international trade, what happens? We are selling things and we are buying things. So for export and import, main important factor or element is what? Cargo and transportation. If something happens to the cargo, then what and where the liability will go, and who will be liable for the same. So these things should be analyzed. So we have risk in transportation too. Then credit, if we are doing something and if we are giving credit to a particular nation with regard to trade, we must aware that that particular nation or that particular country can pay it back or not. If we can analyze those things, then we can't or we will not come across with any kind of risk. Okay. Otherwise, we will give something in credit to the foreign nation, and we will wait for the payment amount, and if we would receive anything, it will cost what loss to us. So it should be foreseen. So analysis is something which will also be like something has to be foreseen. Okay. Then foreign exchange, we must be aware of the foreign exchange rate and all. So, why? Because we are dealing with international trade law. So, in these areas, we will come across with certain kind of risks and all. So, what we have to do is to find out the area from where the risks come across. That means we have to analyze it, then to find out a solution so that we will not come across this, or we should have a free flow or better flow international trade. While coming across to the international economic institutions, we have to discuss and we have to go through the history and all. International Economic Institution, that is IEI. So before that, we have to discuss, because if something will emerge, it will definitely have a source, or it will definitely have some kind of history. Okay. So while emergence of International Economic Institution, the history gives us a picture that it has been formed from this Bretton Woods Conference. So the key actors or the main persons behind this conference was Harry Dexter White from US. He was American Minister of State, and John Maynard Keynes, GB, that is from British. He was a British economist. So they were the key leaders. So we can say that they were the key masters, or they provided the concept of international economic institutions. Okay. So what does this Bretton Woods Conference say? What was the main goal behind, or what was the object behind this Bretton Woods Conference? Because we already stated that there are international economic institutions. So this international economic institution had formed, and it has origin from this Bretton Woods Conference. Okay. So the main idea behind this conference was to govern currency regulation and establish legal obligation through IMF, that is International Monetary Fund. So it provides certain provisions like there must be certain kind of currency regulation. If we are doing international trade, there must be certain kind of currency regulation. And also provide certain kind of legal obligations. So if we are doing the trade and all, there must be certain kind of legal obligation should be there, and that obligation has been provided through from IMF, that is International Monetary Fund. It's a standard for exchange rate, so it also proposed exchange rate must be there, okay? Because it is all about economic institution. Economic institution means what? Where they are providing certain kind of economic help to certain particular nation to deal with trade or whatever for their economic growth. So in that sense, this Bretton Woods Conference suggested that there must be certain rate for exchange rate and all, and establish international finance and currency relationship, and then money pool from which member nation can borrow, so that the money can be accumulated and it can be deposited in one area, so that who are the members of this particular conference, they can take the money or they can facilitate the money for the economic growth as well. So that was the main goal behind this Bretton Woods Conference. The next is ITO, International Trade Organization. Okay, so all this concept came across along with this Bretton Woods Conference. Okay, so participating government reached agreement to reduce obstacles to international trade, and the recommendation was later embodied in the proposed ITO. So whoever participated in the Bretton Woods Conference, what they did, they provided a certain recommendation with regard to trade, and later they embodied it into a law. Okay, so this conference, those who participated in this conference, they formed certain kind of submissions, and they came out with certain kind of recommendation with regard to this economic institutions and all. It established rules and regulations for international trade. Obviously, it comes across with certain kind of rules and regulations which govern the international trade. And the ITO would have complemented the IMF and IBRD too. And the International Trade Organization was not ratified by the US Senate, and it never came into existence. So what was the reason behind this ITO was get a sudden stop? It got a full stop. Because the US Senate did not ratify it, because they found certain kind of irregularity or technical disparity in the field that they didn't give the consent to them, they didn't ratify this ITO, and suddenly it becomes stopped. General Agreement on Tariffs and Trade, that is GATT, was adopted in its place. So instead this ITO, that is International Trade Organization, two other institutions it was adopted. It was GATT. Okay, that is General Agreement on Tariffs and Trade. It came into existence. So replacing this ITO, GATT came into existence. Okay. Sorry. So while moving towards this GATT, it was established in 1st January 1948, and it had 23 members. And in GATT, many rounds of negotiations with related to trade was held. And in the first 7 rounds, what happened was that focus was on trading goods was given, that is with related to export and import. So important, the main focus was given to the export and import of goods. Okay. And in the 8th round, it was held from 1986 to 1994 in a full way. And in this meeting, new areas of negotiations were included like trading service, then trips and films. So the concept of this trading service and all the trips and that is what we say, trade-related aspect of international intellectual property rights and trade-related investment management came into existence. And during the 8th round, member countries decided to set a new organization. Then again a new idea came across, that is GATT was somewhat little bit, it was placed to some extent, and another concept that is WTO came into existence, that was World Trade Organization. It came into existence on 1st January 1995 with 123 members. So here we can see the economic the international economic institutions came across with many institutions like this, what? ICO, then GATT, then later the later one, that is WTO. So these are the history we will see if we come across with this international economic institutions. Okay. So finally the GATT was replaced by WTO, and three official languages of WTO includes English, French and Spanish were included. So the language which has been used in this WTO was three official languages were used. Those are English, French and Spanish. Okay. Then coming to IMF, that is the International Monetary Fund. So all this stuff we can say that is the international economic institutions. So if we say what are the main functions behind this institution is to what? Basically to promote economic health to the countries who are poorer or who can do they can't do any trade if they are lacking capital or like that. So these economic institutions provide support or economic support to those nations who are poorer or who are in the developing stage. So this IMF was established in 1944 and its headquarters in Washington DC, and currently 190 members are there with approximately 2,700 staff drawn from 150 nations. So what's the primary function of this IMF? It is to ensure the stability of the international monetary system. So that is the main function of this IMF, to surveillance if the nations have enough fund or capital so that they can develop their economy. If they are lacking any kind of capital, the economic institution will grant aid so that they can do something like trade and all, and by the way they can improve their economy to a greater extent. So the system of exchange rates and international payments that enables countries and their citizens to transact with each other. So exchange rates and all other means of international payment and all other things were done by supervised by this IMF. So the main function is to supervise. They act as a supervisory committee, or they can be said to be like a supervisor to the nation to find out if any country is lacking in any kind of capital or like that. Then coming to the function, we can see that the main function of this IMF is economic surveillance, as discussed before. Like they will monitor if any country is having any financial crisis or not. Basically, more importance have been given to the developing nations and poorer nations and all for their advancement, like their development, education, their health and all. So they will provide the same to the nation. Then lending, they will grant or they will lend some money for their growth, and capacity building, that's practical and technical help to the members. Okay, so all these are the functions of what IMF or International Monetary Fund, and this IMF is what? One of the international economic institution. Okay. We're coming to the next one, that is WB. What is that? Any idea? Yes, World Bank. So what is the main function of World Bank? Have you ever heard about it? Yes. So what is the main function of WB? World Bank? Sorry? Yes, monetary benefit or monetary help. Okay. You can see that if it is WTO or if it is like the IMF or what we had discussed earlier, the function of everything is to, or every institution is to provide some kind of economic help to the nations. Okay, the basic concept or the basic idea behind all these institutions is the same. Why they are not the different names like IMF or like WB or like that, but the function they serve is the same. The concept and the ideology behind these institutions are the same. That is to serve the developing nation or to help the developing nation to attain their goals. Okay. So coming to WB, that is the World Bank. What is the main function? Provide loans to countries for undertaking developmental programs. So if a country is in a developing stage and if they are lacking something like capital resources or whatever, so if they, whatever they can do by economy or what they can do by financial assistance, they will provide that much financial assistance to that particular nation. family of 5 international organizations. So if you speak about the WB or the World Bank, we can see that many institutions are here under. That is the International Bank for Reconstruction and Development, that is IBRD. It has 189 members. And the International Development Association, that is IDA, it has 174 members. The International Finance Corporation, IFC, the Multilateral Investment Guarantee Agency, that is MIGA, and International Center for the Settlement of Investment Disputes, that ICSID. So these are the institutions which comes under WB. Okay. All these are financial institutions, and the main function of this institution is to grant economic help to the nation which are having certain kind of lagging or fault. Then the particular mission or the object or the aim behind this WB is to provide what is the twin goal, that is ending extreme poverty and building shared prosperity. Sometimes we can say that in order to make an equality in the world, so in order to provide equality among the world, they are providing this kind of facility. That is this kind of facility. They are providing economic facility or financial facility to the countries, and therefore maintaining what? A harmony between the nations. Okay. So, international economic institution. So we discussed it, like the IMF is there, then what the International Trade Organization is there, World Trade Organization is there. Okay, so these are the World Bank is there. So the main function of this institution is to provide what economic and what we say the financial help. Okay. So these international economic institutions have certain kind of functions or certain kind of activities, like assess the individual country's economic environment. First of all, they will assess what is the present scenario, what is the present environment prevailing there. Then extend credit facility to the national government. If they are lacking any kind of economic development, like if they don't have that much capital, then what will be the economic institution will do? They will grant that help. Okay, they facilitate that. Undertake equity investment across the country. They will take investment across the country so that whoever needs assistance, they can provide the same. Then provide multi-lateral guarantees for trade and investment. Then settle international trade dispute and monitor the international monetary system. Then protect IPR across borders, that is intellectual property rights across the border, and provide technical assistance in developing countries, then fund development. So these are the functions of this what international economic institution. So they will facilitate, they will grant credit, and they will lend money, they will provide financial assistance and all. So, an international economic institution established by more than one country and hence a subject of international law. What does it is? If it is an economic institution too, but it has to follow what? International law. And they are guided by international law. If we speak about international trade law itself, it has some of the provisions from international law itself. So in the international trade, we can see the provisions which have been taken from the international law itself. So there is something, the difference is that one is dealing with trade, but the basic concept is like it has some definitions which is already being mentioned in the international law itself. Okay. So it's honors like international economic institution. Who are the parties to this economic institution? So they are the owners or shareholders, generally the national governments, also other international institutions and other organizations occasionally figure as shareholders. So who are or who will be counted as the members or the parties to this institution? Shareholders will be there, government will be there, entity will be there. Okay, all these are parties to this economic institution. The best known international economic institutions were established after the World War II to assist in the reconstruction of Europe and provide mechanism for international cooperation in managing global financial system. So we know that after the Second World War, the situation across the world was like, it was horrible. So every nation something to develop. So if you speak about the European nations, or you speak about the particularly the European nations as well, they faced many things like the financial crisis and all. So mainly the economic institutions were first established with the mind to provide financial assistance to these countries, specifically after the Second World War and to the Euro. So the concept came across. So if we go back to the history, we can see the very back like after the Second World War, there were many financial crises, and then this conference came and they decided and they formed these provisions and rules and all, and they came out with an idea that such institution has to be formed so that they can grant facility to the countries who are really in need of financial stability. Okay. So, this economic institution came across and established after the World War II to access the reconstruction. So we know that after the World War II, any kind of calamity happens, it will be like the situation will be worse. So we need to start from the first. So for that kind of reconstruction, we need huge amount of money. So for that purpose, this economic institution came into existence. Okay. So there are three major international economic institutions, namely, that is WTO, IMF, and UNCTAD, that is the UN Conference on Trade and Development. So here we will come across this kind of economic institutions like we have So under the International Economic Institution, that is ESI, the following institutions are there, like the IMF, International Monetary Fund, then World Bank, then the World Trade Organization. Okay, so main purpose, so the main goal behind this institution is to provide facility, credit facility or financial facility to the country who are in a developing stage or whoever is facing any kind of crisis related to the economic development. Okay. So far, so I hope that you will have got some idea regarding these economic institutions alone. Really? Okay. So the next topic will be discussed later. Thank you so much. ಅದೇ ఇది కొడుకు మైక్ మైక్
எத்தனை போயிடலாமா? நீ ஆப்ரேட் பண்றியா? ரைட் கிளாப் சர்ச் எனக்கு கூட அனுப்பிச்சாங்க. Is anything going into your minds? கண்ணாம போறதா மைண்ட்ல? இதுக்கு முன்ன என்ன போச்சு? International? Sure. Right. So let's continue with the class. Yesterday we have seen the basic mechanism for insolvency and bankruptcy code. What you are please, what I am telling you is, this is the area which you can practice, especially in Chennai. You heard about NCLT, NCALT. Very limited persons are practicing in this course. எல்லாருமே NCLT, NCALT practice பண்றதில்லை. ஏன் பண்றதில்லைன்னா கம்பெனி தான் தெரியாது. ஃபேக்ட் என்னன்னா கம்பெனிலாவே இல்ல, எந்த லாபம் தெரியாது நம்மளுக்கு. எந்த லாபம் ஆமாவா இல்லையா? கம்பெனில எங்கேயாவது போடுறோம். We don't know anything about law. Just to come to the class, you had a good sumptuous lunch, sleep, otherwise for right? Experience? No, that is insolvency. If you want to be insolvency professional, 10 years. But you can practice as an advocate in NCLT. Procedure, as an advocate you are going. Insolvency professionals are different. NCLT you can practice. Some matters will come to High Court also, especially when it relates to Companies Act, everything. So it's a good area of practice for you. Whoever is in metropolitan cities, it's a lucrative practice. Nalla company la terinja, you can become a good corporate lawyer. Right? Yes. Now we have seen the genesis of insolvency and bankruptcy code. Two types of insolvencies has been recognized in the insolvency and bankruptcy code. One is corporate insolvency, another one is individual insolvency. Right? The adjudicating authority is National Company Law Tribunal, National Company Law Appellate Tribunal. இதுக்கு முன்ன Companies Act இருந்தது, அது இப்ப கிடையாது. இப்ப companies, if you want register the companies, run the companies, Companies Act 2013. If you want to close the company, if any disputes arise with respect to company matters, for example, transfer of shares, transmission of shares, now the appropriate authority is National Company Law Tribunal. இதுக்கு முன்ன company law high court போனோம். Sometimes we are going to civil courts also. For example, whether the share belongs to you or not, civil court is the appropriate authority. Now, after the enactment of this code, civil court jurisdiction has been ousted. So NCLT is the appropriate forum to decide about the dispute respect to the companies. Now, let's go into this applicability of the act. In the code, யாராருக்கு apply ஆகுது, and we will see, right? So first one is any company incorporated under the Companies Act 2013 or under any other previous law. So it applies to all the companies incorporated under 2013 Act or under any other previous law. It will apply to all the companies. Second one is any other company governed by any special act for the time being in force. If you go to company law, statutory companies are there. Different kinds of companies la statutory companies பார்த்தோம், அது கூட apply ஆகும். Next one is any limited liability partnership, LLP ன்னு சொல்லுவோம். Any limited liability partnerships incorporated under Limited Liability Partnership Act 2008. Next one is such other body incorporated under any law for the time being in force as the central government to pay by notification specified in this behalf. It could apply ஆகும். Next one is personal guarantors. Personal guarantors யாரு அண்ணா, if the bank gives you the money, they will ask guarantee. You are taking money from the bank. நீங்க பேங்க்ல காசு வாங்கினப்போ they will ask personal guarantors. That means somebody has to give guarantee. So this code will also apply to personal guarantors. That means if the company is unable to pay the money, these guarantors will pay the money and they will initiate corporate dispute and insolvency resolution process. In the main code of the scheme, company மூடக்கூடாதுங்க. The main thing is they want to resolve the disputes of the companies in an amicable manner. ஏதாவது ஒரு டிஸ்பியூட் வந்தா, யார் மீது டிஸ்பியூட் வந்தா, NCLT மீது ஒரு டிஸ்பியூட் கொண்டு போனா கம்பெனி மூட சொல்லி இந்த கோர்ட் சொல்லல. என்ன பண்ணோம்னா அந்த டிஸ்பியூட்டை ரிசால்வ் பண்ணி அகைன் இட் வில் மேக் த கம்பெனி ரன். டிஸ்பியூட் ரிசால்வ் ஆகலன்னா நெக்ஸ்ட் என்ன பண்ணுவா? They will go for liquidation. So entire object of the corporate insolvency resolution process is only to resolve the dispute. If the dispute is not resolved, then enna பண்ணுவா? They will close. For example, you got married. உனக்கு உங்க வைஃப்க்கு டிஸ்பியூட் இருக்கு, டைவர்ஸுக்கு போறோம். டைவர்ஸுக்கு போனா ஃபர்ஸ்ட் என்ன அனுப்புவா? கன்சிலியேஷன். அங்க ஒத்து போனா எங்க போனோம்? வீட்டுக்கு போகணும். ஒத்து போகலன்னா கோர்ட்டுக்கு போகணும். அவ்வளவுதானே? If you are amicably settled, go to home. If not settled, come to courts. இதே மாதிரிதான் இங்க. First they will try to resolve the problem of the company. If the problem is not able to be resolved, then we are going to liquidation. In the proceedings வேறு, அந்த proceedings வேறு. Insolvency dispute resolution proceedings are different. Liquidation proceedings are different. So it applies to personal guarantors, to corporate debtors, partnership firms and other proprietorship firms and individuals. Right. So now we are going to see key objectives of insolvency and bankruptcy code. First one is to consolidate and amend the laws relating to reorganization and insolvency resolution of corporate persons, partnership firms and individuals. In the act வந்தாவிட்டு so many acts எல்லாம் கூட repeal பண்ணா. You know the meaning of repeal? What is the meaning of repeal? What is the meaning of repeal? So many acts has been repealed. That means அந்த act எல்லாம் இந்த ஒர்க் பண்ணாது. Once this code comes into effective, so many acts has been repealed. For example, you have replaced Presidency on Insolvency Act, replaced. Provincial on Insolvency Act, replaced. Sick Industrial Companies Act, replaced. Sarfazi Act, Debt Recovery Tribunals Act, எல்லா ஆக்ட்ஸும் கூட இந்த கோட் என்ன பண்ணிட்டுன்னா override பண்ணிட்டு. That means the code is overriding earlier acts. It is overriding the earlier acts and consolidating all the laws into one insolvency and bankruptcy code. முன்ன இருக்கிற சட்டம் எல்லாம் கூட ரீபிரிண்ட் பண்ணி இது வந்து for example you are having so many acts. Sick industry, SICA is there. Then recovery of debt due to banks is there. Sarfazi Act is there. Debt recovery acts are there. Presidency on Insolvency acts are there. Provincial on Insolvency, all the acts have been replaced by this code. என்ன உன் பேரு? பக்கத்துல என்ன சாப்பிடுற? அதே சாப்பிட்டு எனக்கும் கொடு கொஞ்சம். You are all grown up. ஆமாவா இல்லையா? டவுட்டா? நீங்க grown up இல்லையா? டவுட்டா இருக்கா இல்லையா? LKG பசங்களும் அவங்க வேறு, நீங்க எல்லாம் டிஃபரண்ட் ஸ்டேஜஸ். உங்களுக்கு சில மெச்சூரிட்டி லெவல்ஸ் இருக்கும். அந்த லெவலுக்கு இறங்கக்கூடாது. நீங்க எல்லாம் இறங்குறீங்களா? கிளாஸ் எடுக்கிறாங்களோ சில பேர் சம்படியா ஸ்லீப்பிங். நல்ல மத்தியானம் போய் பிரியாணி சாப்பிட்டு ஸ்லீப்பிங். புரியல? Right. Somebody are peeping over the phones. Somebody has to monitor you. நீங்களே மானிட்டர் பண்ணிக்கணும். You understand? You are all at the verge of completion of this stage. You have to monitor your results. You are all grown up children, right? Small kids kadiyadu. There are some equity attached, right? So to provide for you, this is very important. Time bound insolvency resolution mechanism. Time bound enna? How many days the entire process has to be completed? Very good. 180 days plus 90 days. Yes. 180 days plus 90 days குள்ள எல்லா ப்ராசஸும் கம்ப்ளீட் பண்ணணும். Previously ஒரு கம்பெனி மூணுன்னா 3 வருஷம் ஆகலாம், 4 வருஷம் ஆகலாம், 5 வருஷம் ஆகலாம். இப்பெல்லாம் முடியாது. 180 நாள் plus 180 days குள்ள முடியலன்னா another 90 days கொடுப்போம். Within this 90 days, you have to complete the entire process of corporate insolvency resolution process. Right. Third one is to ensure maximization of value of assets. That means company assets எல்லாம் விற்க முடியாத, they will maximize that. They will keep the assets intact. Company assets எல்லாம் normal assets எப்ப விற்பா கம்பெனில? When the company's assets will be sold, last stage liquidation. At the time of liquidation only company's assets will be sold, liabilities will be settled. But this is not the thing here. They will maximize the value of the assets, keep the assets, try to resolve your problem and try to resolve your disputes. Next book. Right. To promote entrepreneurship, to increase availability of credit, to balance the interest of all stakeholders, including alteration in the order of priority of payment of government debts. If you close the company, you will sell all the assets and you have to settle the liabilities. ஒரு ஆர்டர் இருக்கும். ஒரு கம்பெனியை வித்துட்டா விட்டு அந்த காசு வந்த உடனே ஒரு ஆர்டர்ல தான் பே பண்ணணும். யாருக்கெல்லாம் அப்படி அவளுக்கு கொடுக்க முடியாது. There will be one order will be there prescribed under the insolvency and bankruptcy code. In that order, first you have to give secured tax எல்லாம் கொடுக்க கூடாது. First secured credit, no tax இல்லை இப்போ. First secured creditors. First secured creditors கொடுக்கணும். Next வந்து unsecured creditors. Next payment of employees, workmen. இதெல்லாம் கொடுத்துட்டா விட்டு லாஸ்ட்ல காசு இருந்தாதான் கவர்மெண்ட் கட்டணும். இதுக்கு முன்ன ஃபர்ஸ்ட் கவர்மெண்ட் டாக்ஸஸ் இருந்தது. Now it has been changed. First you have to pay to secured, ஒரு priority இருக்கும். அந்த லைன்ல தான் நீங்க you have to give the amount and settle the disputes. Next item. Right. This is very important. It may be asked in your question. The persons who are not entitled to initiate corporate insolvency resolution process. These 4 categories of persons, they cannot initiate CIRP, corporate insolvency resolution process. Right. We will see who are those 4 categories of persons. Terminology exam இல்லன்னா இந்த terminology exam இல்லன்னா you will fail. You will இதெல்லாம் வரணும். வாங்கிக்கிற நம்ம corporate data, insolvency resolution professional, financial creditors, operational creditors இதெல்லாம் எக்ஸாம்ல கொடுப்பா. Technical paper you have to write something. You cannot write stories like contract and family law. வைமானம் வந்து கேட்பா, which subject are you interested? எல்லாம் ரெண்டு தான் சொல்லுவா. Contract, family. Contract, family. ஏன்னா ஏதாவது சொல்லலாம். எனக்கு வைவால வந்தா இதனால கேட்கிற கொஸ்டின்ஸ் நான். Please, these are the 4 categories of persons. First one is a corporate debtor means company. A corporate debtor undergoing a corporate insolvency resolution process. corporate debtor and debtor means who takes the money. Already அவன் வந்து என்ன பண்றான், ஒரு ப்ராசஸ் ఇనిషియేట్ చేస్తాడు, వాడు మళ్ళీ చేయడానికి కుదరదు. ఫస్ట్ పర్సన్ హూ ఈస్ నాట్ ఎంటైటిల్ టు ఇనిషియేట్ CIRP, కార్పొరేట్ ఇన్సాల్వెన్సీ రెజల్యూషన్ ప్రాసెస్. కార్పొరేట్ debtor undergoing a corporate insolvency resolution process, அவன் பண்ணக்கூடாது. செகண்ட் கேட்டகரி ஆஃப் பர்சன்ஸ், a corporate debtor having completed corporate insolvency resolution process 12 months preceding the date of application. என்னைக்கு அப்ளிகேஷன் போடுறியோ அதுக்கு முன்ன ஆல்ரெடி 1 இயருக்கு முன்னே ஒரு வாட்டி அந்த ப்ராசஸ் இனிஷியேட் ஆகி கம்ப்ளீட் ஆயிட்டு. So a corporate debtor having completed corporate insolvency resolution process 12 months preceding the date of making the application. A corporate debtor having completed corporate insolvency resolution process 12 months preceding the date of making the application. Today you are making the application insolvency. Before the application 12 months preceding, that means 1 year before already a process has been initiated and completed. ఏ రోజుకి అప్లికేషన్ వేస్తావో దానికి 1 year ముందు ఆల్రెడీ ఒక ప్రాసెస్ అనేది కంప్లీట్ అయింది. వెరీ సింపుల్, ప్రాసెస్ కంప్లీట్ అయింది, 1 year వరకు వేయకూడదు, అంతే, సింపుల్. నెక్స్ట్, ఏ కార్పొరేట్ డెటార్ or a financial creditor who has violated any of the terms of resolution plan which was approved 12 months before the date of making of an application. I will tell you the structure. And a corporate debtor in respect of whom a liquidation order has been made. Normally 3 types of persons இருப்பா கம்பெனில. இவங்க என்ன பண்ண முடியும்னா they can initiate corporate insolvency resolution process. Very simple. First யாருன்னா financial creditors. That means who has given money to the company. Investors కాదు, who has given money to the company. Money, financial institutions, banks, financial creditors. First category of persons யாரு அண்ணா financial creditors. ஏன்னா அவங்க காசு கேட்டாங்கோ, காசு கொடுக்கல, அவன் என்ன பண்ணுவான், NCLT போவான். என் காசு வரலன்னு சொல்லி he will go before NCLT. First category of persons யாரு, financial creditors, right. Second category of persons யாரு அண்ணா operational creditors. கம்பெனிக்கு சப்ளை ஆஃப் ரா மெட்டீரியல்ஸ், சப்ளை ஆஃப் சர்வீசஸ் கொடுப்பான். அவன் என்ன கேட்பான், நான் ரா மெட்டீரியல் சப்ளை பண்ண, சர்வீஸ் சப்ளை பண்ண, ப்ளீஸ் பே மீ தி மணி. கொடுக்கல.
இந்த கோர்ட் அப்சர்வேஷன் இந்த ரெண்டு 150 rupees
இப்போ வாங்கப்பா.
after 4 o'clock.
Right. After attendance.
150 rupees.
Claps இல்ல, நீ கிளாப்ஸ் அடிச்சா 4 மணி நேரத்துக்கு இங்கே நிக்க இருப்போங்களா, புரிஞ்சுதா? What many days? Tell me. Up to? No, I will continue up to 5. No issues? Right. Yeah, please. Investors are different. Investors కూడా మళ్ళీ లాస్ట్ లో అమౌంట్ పే చేయాలి. You understand? They are taking shares. They are shareholders. Investors are shareholders. Banks డబ్బులు ఇస్తుంది, బ్యాంక్ షేర్స్ ఇస్తుంది ఆ కంపెనీ. మరి Simple logic miss ayipothetla. Banks will give the money. Will company will give money to banks, shares to banks. But CDR lo istundi, corporate debt restructuring lo istundi. Right. Simple logic. So first category of persons is financial creditors. After this class, after signing your attendance, everybody has to take court observation note by paying rupees 150. புரிஞ்சுதா? காசு இல்லையா? 150 ரூபாய் இல்லையா? புரியல. Only cash. You have to take. I am giving prayer intake half an hour before. No, tomorrow onwards, court observation is there for you. After signing of attendance, you have to take internship notes by paying 150 rupees and you have to take the book. Book கொடுப்பாங்க. 150 ரூபாய் கொடுத்து book வாங்கணும். No, only cash. Right. Yeah, please. Yeah, please. Still 10 minutes is there. Let me complete structure. In the structure there is in that you can write exam on your own. This is the structure I have to tell you. First category of persons is, please listen. Please, first category of persons are financial creditors, right? Second category of persons are operational creditors. That means who has supplied raw materials, supply of services ஏதாவது இருக்கலாம். அவனுக்கு காசு கொடுக்கலன்னா அவன் கூட இனிஷியேட் பண்ணுவான். Third category of persons is corporate applicant. Corporate applicant includes corporate debtor plus employees of the company also. 3 persons are entitled to initiate corporate insolvency resolution process. Yes. Now, any of the persons, they will go and file an application. என்ன file பண்ணுவாங்கன்னா NCLT. That is known as adjudicating authority. Any of these persons, let it be a financial creditor, operational creditor, corporate applicant, anybody can go and file the application before the adjudicating authority. On the application order, they have to mention a person's name as interim resolution professional. அந்த அப்ளிகேஷனோட ஒரு பேர் மென்ஷன் பண்ணணும். என்ன பேர் யாருன்னா, இவன் வந்து எங்க கம்பெனியில he will undertake insolvency resolution process. He is known as interim. You know the meaning of interim? Middle. If this interim resolution professional name has been accepted by adjudicating authority, he will become final professional. First ஒரு பேர் கொடுக்கணும். பேர் கொடுத்த உடனே ஒருவேளை பேர் ஒன்னும் கொடுக்கலன்னு நினைச்சுக்கோ, யாருக்கு? adjudicating authority. Adjudicating authority will issue notice to Insolvency and Bankruptcy Board of India to appoint interim resolution professional. You understand? If no interim resolution professional is appointed, the adjudicating authority will give notice to Insolvency Bankruptcy Board of India. They will give one name. Right. Now, interim resolution professional has been appointed. Now, what he is going to do is, he will constitute a committee of creditors in the company. என்ன பண்ணுவான்னா, அவன் வந்து he will constitute a committee of creditors in the company. This is next stage.
வைண்ட் அப் பண்ணிடலாமா? ஆல்ரெடி 3.5 பண்ணிடலாம். பண்ணிடு.
అక్కడ అయిపోవచ్చు అவ்வளோதான் நிறையா இருக்கு ஜஸ்ட் லீவ் இட் பார்ட்டி இங்க வாங்கணுமா అటెండెన్స్ వాంగిట్టేనಲ್ಲ இப்போ అటెండెన్స్ అది తీసుకున్న తర్వాత కదా అది బోత్ అట్ టైమా I told already.